Good afternoon, everyone. Are we good to go? All right. Um, Welcome to the second in a series of 4 webinar sessions dedicated to private equity investment in the healthcare industry. I'm Mark Vecchio, the chair of the corporate group here at Venable. I'm sitting in today for my partner, Ari Markinson, the head of our healthcare practice, who unfortunately was not able to join us. He sends his best and will be resuming his generally and ordinarily scheduled role as monitor and moderator for these sessions and the upcoming sessions later in the year. I'm joined today by my partners, Len Gordon and Bill Vigen, two utmost experts in the world of antitrust as a general matter, and in particular as it relates to the healthcare industry. And as foreshadowed, we are focusing in particularly on how questions of antitrust affect private equity investors in the United States. So without further ado, let me introduce my partners. We'll start with Len. Please, Len, can you let the group know a little bit about yourself?
Sure. Thanks, Mark. Delighted to be here. Welcome, everyone. I'm Len Gordon. I work in the advertising and antitrust groups here at Venable. I've been at Venable about 12 years, and I joined Venable from the Federal Trade Commission, where I ran the Northeast Regional Office of the FTC here in New York. When I was at the FTC, we focused quite a bit on healthcare. We reviewed many hospital mergers, retail pharmacy mergers, doctor alleged price fixing, and then also some healthcare stuff on the consumer protection side. Since at Venable, still do some of all of those types of things, and I'm delighted to talk to you today about a really interesting issue with private equity in healthcare. It's front page news daily, so we've got a lot to talk about, and I'll turn it over to Bill to introduce himself.
Thanks, Len. My name is Bill Vigen. I'm a partner in the Antitrust Group in the DC office. Here in the Antitrust Group, we sort of handle everything antitrust soup to nuts, corporate counseling. We do HSR filings for mergers and acquisitions for our corporate group, including a lot of private equity deals. And then I also do antitrust litigation, both civil and criminal, when it comes to things like price fixing or market allocations.
Great, thanks, guys. So I was a bit remiss just to remind everyone we are recording this session today, and we're going to be invoking Chatham House rules, meaning what we're saying today is essentially off the record in the context of this private conversation. Our remarks and our thoughts are our individual views and not the views necessarily of our firm or of any of our clients. To the extent that you have questions, and we hope that you will, please enter them into the chat. You can do so sort of while we're talking, or you can sort of do them at the end. We'll leave about 10 or 15 minutes at the end of the session today to respond to some of those questions. But don't hesitate to actually enter the chat during the course of the conversation if you have questions that do pop up. So I'd like to start us off today with just giving us sort of a general basic introduction and background as to sort of what has been happening in the context of antitrust given the last couple of years with respect to the healthcare industry. Len, maybe you can help shed some light on the sort of relative accordion effect of enforcement versus lack of enforcement, regulations, and where we see things and where they are relative to where they may have been in the past 5 or 10 years.
Sure. I'll sort of give us a where we are now, and then I may ask Bill to sort of give us some historical perspective, because antitrust has been a hot topic for healthcare for some time, and healthcare has been a hot topic for antitrust for some time. I think right now you're seeing probably one of the more heightened areas of government antitrust enforcement. Remember, the antitrust laws are enforced both by private plaintiffs and also by both the Federal Trade Commission and the Department of Justice and state attorneys general as well. So there's lots of actors here. Both the FTC and the Department of Justice have said and then acted with the intent to really ramp up antitrust enforcement. Merger enforcement is way up. You're seeing heightened requirements for merger filings, heightened scrutiny of merger filings, and somewhat of a change in focus. I mean, historically, the agencies they've withdrawn their merger guidelines, they've proposed new guidelines, and those guidelines are in some ways a little squishier, I would say, than in the past. They take a broader, more holistic approach. There was previously a real focus on consumer welfare. Will this merger, will this conduct raise prices or lower prices for the end consumer of goods or services? The agencies now are focused much more on a variety of factors. There's privacy concerns that motivate antitrust enforcement, and employee concerns. That might be the biggest change. So in evaluating hospital mergers, for example, you may see the Department of Justice or the FTC assessing what the effect of that merger will not just be on insurance rates and patients, but also on nurses or others who work in or adjacent to the hospital. And that's a real change. There was a merger in New England last year, the year before, that ultimately was abandoned. But one of the grounds that the FTC was prepared to challenge that merger on was its effect on nurses, and that came as a surprise. But that is clearly an area of intense focus. The effect that mergers have on employees, and it's something that historically I don't think antitrust lawyers worried about very much when they were evaluating a deal, but now you have to. The other thing that the agencies are doing, and I'll let Bill talk about this a little bit because he was directly involved with it when he was at Justice, is they're using the review that happens, pursuant to a second request, not just to assess the effects of that merger, but to look for evidence of other conduct, including criminal conduct. They are looking for evidence of no poach agreements, agreements between companies not to poach each other's employees, agreements that might with suppliers that might raise issues. So that also, I mean, it's going one way, and I know Bill has a lot of familiarity with that. And Bill, you might want to just talk a little bit about the use of merger review to potentially feed potential criminal cases.
Yeah, thanks, Len. Yeah, it's absolutely true. Len referred to it, my experience at Justice. I forgot to indicate that I joined Venable a year ago from the DOJ Antitrust Division, and I was specifically in the criminal section side of things. But quite often, criminal investigations start because of a merger review and documents that are submitted pursuant to second requests. And the department, FTC as well, when they are reviewing, will frequently find instances of conduct that they want to explore, either civilly or for a criminal referral. So the agencies are working together, FTC referring even criminal matters over to DOJ based on HSR filings and second requests, particularly once you get into digging into the emails. And same with the civil side of things on the antitrust side. I think in terms of the focus on private equity and healthcare, I think this is sort of just a continuation of kind of the new left antitrust enforcers, where they kind of have this big is bad mindset. They're against consolidation in industries generally. You see them going after the tech defendants. They're kind of quick to lob accusations of abusive dominance. And unfortunately for antitrust practitioners, they're slower to accept arguments about efficiencies and cost cutting. And it's particularly ironic, I think, in the healthcare space, because typically you talk about cost cutting as an efficiency enhancing aspect of any type of deal or anything that they're looking into, that can actually lower the price of healthcare for consumers. And the enforcers are kind of looking at it and saying, well, you're also hurting the standard of care. It's hard to have, I think, both, and they're kind of attacking it from both sides, which is a little bit unfortunate. I think too, though, in terms of, Mark, you were talking about the history of all this. I think it really started basically back in the late 70s, early 80s, but you kind of see it mirroring the politics of the time. So sort of early on, it was very standard, easy, low-hanging fruit type of things that promoted competition. So the enforcers were going after restrictions on advertising. So back in the 70s, the optometrists would say you can't actually advertise the price of eyewear in a newspaper. They got rid of those restrictions to encourage price competition. Those are pretty easy things to go after. And then in the 90s, and this is sort of relevant to today, related to President Clinton's healthcare overhaul reforms, you saw the antitrust enforcers putting out these policy statements, guidelines in the healthcare space that provided safe harbors, encouraging private competition in the healthcare market, encouraging hospital mergers with the idea that this would drive down patient costs. All of those safe harbor guidelines were withdrawn last year by DOJ and FTC. making, I think, this area generally riskier, kind of in line with their current politics, that they explicitly said they thought the pendulum had swung too far toward too much consolidation, and they wanted to get rid of these safe harbors, which has increased a lot of uncertainty in the area, not just for healthcare, but really for everyone in the antitrust bar who use those safe harbors. Not even though they were designed for healthcare, people would take the guidance, for example, for information sharing and use that same type of safe harbor for all sorts of information sharing, even outside the healthcare space. So it's really raised the uncertainty level for us as antitrust practitioners, sort of industry-wide, market-wide. And DOJ and FTC have been very explicit that they do not expect or are planning to provide any type of replacement guidance. They kind of like the uncertainty because they understand, as economists, that kind of drives up the cost of doing business and less deals might get done. From their perspective, in this current political environment is a good thing.
What happens in November? There's one of two outcomes, right? We have either a continuation of the Biden administration or we have a new Trump 2.0. Can you venture a guess as to what happens in November, depending upon the outcome of the elections, as it relates to enforcement and general issues relating to antitrust from coming out of Washington?
I think it's a little hard to predict. I mean, the Trump administration 1.0 was anti-regulation, except I think on sort of tech. I think big tech remains sort of a target for the Trump administration. On healthcare, I mean, they do purport to be more business friendly, and I think you will probably see a little bit less enforcement. It's hard to say if President Biden is reelected. I think you'll see more, and it will also depend on persons. Who the Attorney General is, who's the chair of the FTC, who the head of the Antitrust Division is. Personalities matter. Sometimes an energetic leader really can make a difference, and it's very unclear right now who would lead on the Trump side. I know there's names bandied about, but no one really knows. Bill, if
Biden's elected, do you think Lena Khan stays? Or
I do. I do. I think she stays for a while. I think she's. I think she likes her job, and I think she's enjoying her soapbox.
Yeah, I think the one thing we can say for sure is if Biden wins, right, I think this focus on private equity will remain. I think that's a pretty safe bet. Whether it's Lena Khan or her replacement, same with Cantor at the Antitrust Division, I think their replacements will just be proteges. So I would expect it to continue if Biden wins. I think, as Len said, it's a little bit more up in the air with Trump. It really does depend on who is going to be installed as the head of these agencies. I think the focus will probably be less drastic on private equity, but it does depend on those personalities of who's put in. This doesn't directly have to do with the healthcare space, but just as an example, one of the bigger initiatives at a DOJ was to prosecute criminally employee no-poach agreements, so agreements between employers not to hire each other's employees. And most of those cases have hit roadblocks and have happened or have been carried out under the Biden administration, but the indictments were actually approved under the Attorney General for Trump in the first instance. And most of those actually occurred in the healthcare space. So, for example, no-poach agreements among physical therapist staffing companies, those sorts of things. So it really kind of does depend on, I think, the leadership that gets put in charge of the actual agencies.
I think one of the big changes, if there's a Trump administration, is the focus in merger analysis on the effect mergers have on employees. I think that will change. There has been discussion in assessing mergers that if jobs are eliminated because of consolidation and efficiency, that's a bad thing, and it should be considered anti-competitive. And that's, I think, a shock to most investment bankers or other economists who generally think that that's efficiency enhancing and ultimately leads to a better, more efficient economy. So I do think that will change, and that would impact hospitals and also physician group mergers where some of the overhead is to be withdrawn. I mean, just to step back for a second and talk about antitrust enforcement in healthcare and how it affects private equity. I mentioned before, there's lots of actors, and it's a really complex ecosystem because the Justice Department and the FTC share enforcement. There's a clearance process. So, if a deal comes through, certain deals almost automatically go to one agency or the other, but some of them, there's some arm wrestling that goes over. Health insurers, consolidation there always goes to Justice. Hospitals mostly goes to FTC, at least recently, but the Justice Department occasionally does that. Extent we're looking at physician practice consolidations, that would probably be at the FTC. When we start looking about conduct, it gets even more complicated because the FTC has the ability to challenge mergers among nonprofit hospitals or nonprofit healthcare providers, but it does not have the jurisdiction over conduct remedies. So if two nonprofits were allegedly fixing prices, that's something the FTC couldn't challenge. We refer that to justice. So it really is a mess in some ways in sort of how the enforcement set up. The other thing about healthcare is it's different. If we're talking about cars and I can't afford the nicest car, I don't buy the nicest car. But if you have a sick kid, you want the best care for that kid. And, the way we normally ration things, through price, it doesn't work the same for healthcare. First, you've got insurance and, you've got a huge public payer component to this. So the market dynamics are different. The insurance companies are essentially seen as proxies for the consumer, but as these insurance companies have gotten bigger and bigger, some people question how accurate that is. So it's just the sort of the normal competitive dynamics that you would rely on to analyze the market are just more complex when you've got insurance companies and patients and providers and employers who often are funding large parts of the insurance premium. It just makes the analysis trickier and a little less certain, which are not things that businesses like to hear.
An additional point on that score, right? Not everyone is a car buyer. You use the analogy
right.
of a car buyer, but everyone is is a user at some point in their life in health care, right? Yep. And so it truly is one of those services that affects every single human being, not only in the country but on the planet. Yep. Unlike pretty much any other service or product you could imagine.
Yeah, which is. People are willing to cut corners on buying lots of things, but again, not too many people want to go to the cut rate hospital. No, but something that's serious. So that makes it difficult.
No, it's a good, absolutely good.
The other thing, just as these sort of I think are stage setting issues, is in many ways you see what when I was at the FTC, I thought of it as an arms race, and there were two different arms races. There was an effort by the insurers, the payers, to consolidate, to have more leverage when they were negotiating with providers. And correspondingly, there was an effort by providers to consolidate so that they had more leverage to deal with consumers. And in defending their mergers, both would say, we need to get bigger to deal with the other guys. And so it was actually very interesting, but it has led to enormous consolidation on sort of both sides of that. I think, the current administration questions the wisdom of allowing a lot of that consolidation to go forward. The other aspect of this, and this is really just on the provider side, is there's a technology or equipment arms race. The robot surgeries and really advanced medical imaging equipment is enormously expensive. And especially in rural or ex-urban communities, whether local hospitals can afford that is a challenge. And if there's two local hospitals, whether both of them can afford that, if they can't sort of say, well, I'll do this and you'll do that, that's a horizontal market allocation. So that's a problem. But, that issue of how these hospitals can afford to make the investments necessary to have the best care, and whether they should or should patients have to go further to get that care if they live in more remote areas. Again, these are sort of policy issues, but the antitrust laws frequently have to deal with these. One of the recurring things we saw when we were looking at hospital mergers when I was at the FTC is you would see these areas that probably needed 1.5 hospitals, and there was some consolidation, and you're like, it was what did you do? And we'll talk later on if we have time about a case outside of Charlotte, North Carolina, where some of those issues came to bear, and the FTC actually just lost an effort to block a merger. But again, these because these are big things, hospitals, enormous investments, enormous employers, enormous presences in the community. When they merge, it has lots of effects, which makes the antitrust analysis complicated.
No, super interesting. Bill, I wanted to ask you, you work in Washington. The FTC is a federal agency. The DOJ, Department of Justice, is a federal agency. Are antitrust laws limited to the realm only of the federal government, or are the states now also getting more involved in this game?
Yeah, no, that's a great question, and also kind of loops into what won't change regardless of what happens in November, which is there's been a increasing number of states who have filed what we call baby HSR acts. So these are state laws that require notification of mergers, and specifically in the healthcare space. And so that's going to continue. And I think we're up to 15 states now, probably going to be growing, including California and New York. And the reason I think for those, and why I expect sort of continued state interest in the healthcare space, are you have these doctor groups and these local hospitals that are, as Len touched on, they kind of touch on the core issues of your community and how people interact with a very important part of their budget, which is their healthcare spending and their life. The states are interested when those are coming together, or consolidation, the impact that that's going to have on their local communities. And so the filing requirements in those states are a lot less for hitting the federal HSR. So I think it might be as little as a $25 million deal as opposed to a $120 million deal at the federal level that would have to get notified. And we've already seen a few that have gotten blocked or have, because of the holdup, have been abandoned. So I do continue to think that that's going to continue and only become a bigger issue as folks are going to have to navigate at the local level as well.
Again, I'm sorry, Bill. There's another aspect to that, and that's the state regulation of healthcare and the extent it might displace partially or wholly the antitrust laws. In New York State, for example, the Department of Health, there's been a bill passed by the Assembly and enacted in the law that essentially gives the Department of Health the ability to supervise hospital mergers and certain other mergers, and explicitly says it's meant to displace the antitrust laws, and the Department of Health will actively supervise the merger and the ongoing conduct such that state action immunity applies. That hasn't been challenged yet, but the Department of Health is sort of like the central planner now in New York for hospitals. I mean, it's picking winners and losers. It lets certain hospitals go broke, and it lets it will help arrange funding, and it will say it goes to, a hospital needs to refund, refinance. It will tell the hospital that, you need to get a better rate. It will tell the banks, you need to do better for this hospital. It's really fascinating, the amount of government involvement, completely displacing competition. And some people say, well, competition hasn't worked because a lot of the factors I was mentioning before and Bill's mentioned before, the sort of unique attributes of healthcare that maybe competition and having, losers, having hospitals go broke, or hospitals achieve dominant position because they just provide the best care isn't the right answer. And so, New York has sort of displaced that. The other aspect of this is state licensing boards in healthcare. There have been two cases the FTC has taken to the Supreme Court in the last 20 years, both dealing with whether activity by state licensing boards essentially was immune or exempt from the antitrust laws because of state supervision. In both instances, the Supreme Court said it wasn't. One dealt with teeth whitening in North Carolina, where a group of dentists who ran the dental board would make rules about non-dentists providing teeth whitening, and ultimately the FTC felt, and the Supreme Court agreed, that having active market participants regulate market activity is not sufficiently state activity to qualify for state action immunity. And then there was a hospital merger in Georgia where the part of the state founded a special purpose entity to roll up a couple of hospitals, and the FTC challenged that. The hospital said, no, this is state activity. It's been authorized by the state. We're exempt. And there again, the Supreme Court agreed with the FTC that the activity was too private. It wasn't really state activity. It was private activity, and the state decision to roll these hospitals up didn't displace the antitrust laws. But again, the state very active in healthcare, and
it sounds like there's actually some tension between what's going on at the state level and what's going on at the federal level, right? So they're effectively sort of fighting each other.
Not just that, you sometimes have instances where the antitrust folks in the Attorney General's office and perhaps the licensing folks in the Attorney General's office are disagreeing. So it's makes for odd holiday parties. But one other aspect of all this is, frequently, when you're doing merger analysis, you'll say, all right, well, if these companies merge and they raise prices, who will enter to replace that competition or to enhance that competition? Entry in healthcare, especially at the hospital level, is much more complicated because of the capital and lead time to build a hospital. But you've also got state certificate of need laws, and having to if you want to be a new entrant, you've got to get a certificate of need in many states, and it just makes the analysis more complicated, and it really does show you how involved state government is in doing this. It was interesting when I was at the FTC, the fellow who was running the Bureau of Competition sort of said, we're not going to challenge hospital mergers unless the Attorney General is standing next to us, because the politics and just sort of we can look at maps, but you need somebody who lives there to really understand whether people actually cross that highway to go to that hospital. Or they go the other direction. So, hospitals mergers really are very localized, and there's a lot of state politics, and it just makes the analysis much more challenging, I think.
Yeah. Talk about a minefield, stepping your way through the minefield. I wanted to switch gears a little bit. We were talking earlier about non-poaching agreements and the extent to which those kinds of agreements raise issues under the antitrust laws. And on a related topic, non-competition agreements, non-competes are now all in the news, not only in the context of healthcare, private equity, but every single industry across the board, in light of recent regulations promulgated by the FTC, Federal Trade Commission, essentially banning non-compete agreements. Can one of you tell us a little bit about sort of what the status is today? It seems like things are a little bit in flux.
Yeah,
at least from
Bill,
my perspective.
Yeah, Bill, go ahead.
Yeah, sure. Yeah, so the FTC issued that rule after almost a year of notice and comment in April of this year. Not surprisingly, it was immediately challenged by the business community. And we're sort of still in a state of flux, as you said, Mark. It is technically set to go into effect September 4th, 2024, but the courts where those cases are in front of obviously know that is when the rule is going to go into effect unless they rule. And the case that I think is probably first filed in the Southern District of Texas, the judge down there said that he would issue a ruling by July 3rd, one way or the other. Obviously knowing that whichever way he rules, it's going to be appealed by either side up to the Fifth Circuit. And so that's going to build in enough time. I guess the idea is for the Fifth Circuit to rule before that September 4th deadline. So it's still anybody's guess in terms of how that shakes out. But yes, I mean, currently that is the angle for the FTC to take to ban these non-competes. Perhaps that rule gets withdrawn if there's a Trump administration and the court fight becomes kind of moot. But that's where we are at federally.
And there's some really interesting legal issues as to the validity of that rule. The FTC has not issued a competition rule in 30 plus years. There's a genuine debate about whether the FTC continues to have competition rulemaking authority. So regardless of this rule, whether it has that authority generally, this also is not an area where the FTC has a great deal of experience to justify it making a rule. I mean, with the FTC, they announced their first non-compete cases about a week before they announced the proposed rule. So for 100 plus years of the FTC's existence, it hadn't anything to do really with non-compete agreements, and then suddenly it brought 3 cases, and a week later said, "Oh, we think we have so much expertise here that we should write a rule on this and displace hundreds of years of state law." So it'll be interesting to see. In this case, not by accident the challenge to it was filed in the Fifth Circuit, which has been historically very hostile to the administrative state. That's where most of the challenges to the CFPB's authority have been lodged. Again, not by accident. The Fifth Circuit found the CFPB was unconstitutional. The Supreme Court recently disagreed, but there's still a lot of favorable precedent. If you're challenging the growth of the administrative state, you generally would want to be in the Fifth Circuit. So we'll see.
Yeah, and interestingly, from the perspective of an investor looking at businesses, specifically in the healthcare space, specifically in the provider space, right? Your single greatest asset often are your people and your ability to keep your people. And if all of a sudden you now are faced with a situation where non-competes are not effective, and doctors and nurses and practitioners and anesthesiologists can get up and walk across the street and work for a competitor, that obviously adversely affects valuations. So it absolutely has an impact. It will have an impact in this industry, as is the case in other industries as well. So again, maybe pro-competitive, maybe not necessarily a good thing, depending upon where you sit on the food chain.
Yeah, it was interesting when the FTC was considering the law. There was a lot of talk about should there be sort of income thresholds that if you make enough money, you can be subject to a non-compete. And the FTC ultimately, at least at the forward-looking part of the rule, said no, everybody's subject to it. They did carve out high-level executives, sort of in eviscerating the non-competes that were in place. A lot of the impetus for this was really on non-compete agreements that were imposed on service workers in the fast food industry, and the argument as to why those people need protection seems to me a lot different than why a cardiothoracic surgeon might need protection. But right now, at least the FTC's rule applies to both of them equally, and I'm certain that will be part of the grounds of the challenge, that the rule is not appropriately narrowly tailored.
Yeah, particularly given the notion that you can arguably negotiate for a quid pro quo in terms of a non-compete, right? There's value there. You can get compensation.
Exactly.
Right? It would seem from us mere contract lawyers that you're now invading the space of the ability and freedom of contract.
Yep.
But who am I to say? Bill, I wanted to ask you in particular, this is obviously a series dedicated to private equity in the healthcare space. It seems like there's a bit of a, whirlwind where the regulators in DC are targeting private equity specifically as the bad guys. Is that a valid perception? Am I exaggerating? Tell us a little bit about what's going on that front.
No, I think the perception of in terms of that's happening, I think that's probably true. Unfortunately, I think they have had hearings and notice for public comment, specifically targeting private equity. I think I had said earlier, I think it's part of just this mindset of big is bad. But then I also think part of what's going on is they, based on roll-ups and smaller deals in the healthcare space, because of the fact that we're talking about local practice groups that can be bought out without any type of HSR notification. I think part of what's going on is, the FTC, DOJ felt like there was a lot going on in the economy with respect to healthcare that they didn't know about because they weren't subject to the filing, and they kind of just got uneasy about everything, not knowing and not having a better idea or control over it. And I think that's part of a little bit of a knee-jerk reaction of them wanting to make sure they have a better handle of what's going on, feeling that there is this potential for abuse, and being, I think, just because they lack understanding of how it may work, a little bit of the fear of the unknown, and it's just another boogeyman that they can go after. And unfortunately, that is what's happening. I think they've seen some isolated incidents of conduct that might concern them that they've investigated, but now they're trying to expand it into the entirety of the industry.
It's remarkable though how much of this you are seeing. Private equity essentially has become the new boogeyman for why healthcare is expensive. On May 30th, the Journal, the Wall Street Journal, not the Daily Worker, ran a piece, you can thank private equity for that enormous doctor's bill, and talking about how private equity, at least in their view, was driving up the cost of healthcare. So if the Wall Street Journal is, publishing articles like that, I think the industry's got to think about how to better explain the value they provide. I mean, I was talking before about, the equipment arms races. That equipment costs, hundreds of thousands or millions of dollars, and that money has to come from somewhere. So, I think that I'm not a public relations expert, but there is a public relations war going on, and the community needs to probably do a little bit more. If that wasn't scary enough, yesterday, Senators Warren and Markey from Massachusetts introduced legislation that would impose criminal penalties on private equity firms and their executives if people died from the profiteering or looting at hospitals owned by private equity firms. So, the syllogism is, the private equity firm stripped the cash out of the hospital. Someone went to the hospital and didn't get the care they needed, and they died. The private equity firm, and perhaps the executives of the private equity firm, should be charged criminally for that conduct. I don't think that bill will pass, but it's frightening that, people are talking about those kinds of things on the floor of the United States Senate. And I think it shows you how hot at least some members of Congress are about the perceived ills that private equity is doing to the healthcare community.
Yeah, well, particularly when you're taking a specific industry. I mean, why not focus on strategics who are also involved in, mergers and acquisitions and creating economies of scale and trying to squeeze efficiencies out of our system. It seems a bit interesting, to say the least, that regulators are focusing on private equity per se, as if they're some sort of a special animal, and one that, killing the golden goose is sometimes the analogy that we see in that context. But interesting stuff. What about, are there any recent examples of enforcement activity that we can talk about without necessarily naming names, but just kind of giving folks on the call today a little bit of a sense of, in the real world, practical terms, what kinds of things are happening?
Well, sure. I mean, I can talk about a case that happened down in Texas recently, in the anesthesia field, and this was brought by the FTC, and they challenged a private equity firm's roll-up of a large group of anesthesia practices in Houston, Dallas, and really throughout the state. The firm, cast in sinister overtones by the FTC, began consolidating to drive up profits. Profits apparently are a bad thing. But after each roll up, the rates did go up, and ultimately 15 different anesthesia groups were acquired. There was also allegations that they had paid a group in a potentially competing group to stay out of a potential market. So that's not the kind of conduct the FTC likes. They got 70% market share allegedly in Houston and Dallas, 52% in Austin, about 60% nationwide. And the FTC sued to unwind these deals, and didn't just sue the large anesthesia practice group, but also sued the private equity firm that was the quote mastermind of this strategy and was the largest investor in the funds. Originally, that private equity firm had owned a little over 50%. They sold part of it and came down to around 23%. And this is actually some of the stuff we were talking about before about the difference between the Justice Department and the FTC's ability to go after conduct. It comes up. The FTC's ability to go to federal court is a little bit limited. They can use Section 13B of the FTC Act, which allows them to go to court if they can show that the defendants are violating or about to violate a law that the FTC enforces. The Justice Department has a broader grant of ability to go get an injunction from a judge. The judge, the defendants moved to dismiss the entire case. The judge refused to dismiss the case against the anesthesiology practice, but ultimately did dismiss it against the private equity firm because the judge found that you could not the FTC could not allege facts indicating that the private equity firm was violating or about to violate the antitrust laws. And some of the parts of the judge's holding are some good news. We've given you guys a lot of bad news about private equity, but he said, just owning an entity that may be violating the antitrust laws is not enough to find that the private equity firm or any company that owns some portion of that practice is violating it. It's not an independent act, and the FTC couldn't show how that its ownership, the fund's ownership and its right to appoint 2 of a dozen board seats in itself reduces competition. So that's sort of just being a passive owner essentially isn't enough to show that you're a violator of the antitrust laws, which is important because not just the government, but you've got private plaintiffs out there who are always looking for deeper pockets, and there are deep pockets obviously in private equity. And the FTC also says, well, they're about to violate the law because this is their business model to buy companies and drive up prices. And the judge said, that they could in the future buy companies that might, in a way that could be anti-competitive, is not enough to show that they were about to violate the antitrust laws. Every company could have buy somebody potentially that deal might violate the antitrust laws, or could agree with somebody tomorrow to do something that violates the antitrust laws. You need something more than that potential to get to court. The judge did find that the anesthesiology practice was continuing to violate because of the way that they were continuing to hold assets that at least were alleged to have been acquired illegally. So, there's been some private litigation against private equity firms as well. There was a lot of action in the tuna industry where the allegation was that private equity executives were the conspirators to a price fixing conspiracy among companies that sold canned tuna and other tuna. And some of the private equity firms have gotten out because they just appeared to be passive owners. Others who appeared to have been doing some of the communicating that supported the inference of a conspiracy are still in. So, and there's been criminal conduct in some of those cases as well. So, if you're an actively managing the company, obviously your risk is going to go up. If you're passive, it mitigates your risk. So, Bill, I don't know if you've got thoughts on any of that.
Yeah, no, I just had another case that I thought was interesting that touches on the HSR issue I had been talking about. There was an acquisition, a merger in the veterinary space, and the FTC allowed that to go through after requiring a divestiture, which is not abnormal in any industry really, to impose that type of requirement where they thought there'd be a lack of competition in certain cities. But the interesting thing was, for the first time really ever, they had put in the settlement agreement a prior notice requirement that if the private equity group was going to do additional add-ons in this space, that they would have to notify the FTC regardless of the size. So again, this idea that maybe the HSR Act is not capturing a lot of the information that the FTC is interested in. So I think it just goes to the FTC and DOJ wanting more insight into this area.
Yeah, and that's actually a great point. I mean, not only are you seeing enhanced enforcement or more enforcement activity by the agencies, but the remedies that they're willing to accept to resolve competitive concerns have gotten much stricter. They're not convinced that divestitures of certain overlapping assets are sufficient to replace the competition that's lost. So I think that the burden on the parties to demonstrate why that divestiture might cure the competitive ills is higher. And they would rather just kill deals. I think they would, in many instances, they would rather litigate the case and lose than accept what they view as a weak divestiture. You're seeing that in the pharmaceutical space, where they're not accepting divestitures of certain key overlapping product lines. You're seeing that in lots of areas where what they want is a lot more, and you're seeing the kind of notice provisions that Bill just mentioned in a lot of the deals that they actually do accept. So it's a hostile to deal activity, and the uncertainty that this creates is viewed as an enforcement tool.
Yeah, Len, dialing back to the case you were discussing 5 minutes ago about sort of the extent to which an investor could or could not be held liable with respect to the activities of its portfolio company. It sounds to me like that could be a sort of much more of a facts and circumstances type of a situation. And you described sort of the goalposts of, purely private passive investor versus if you're involved in the day-to-day management of the company, are two different situations. But most private equity investments fall somewhere in the middle of that spectrum, right? Where you have, of course, depending upon your equity interest, but you might very well have veto rights. You may very well have a board representation. More likely than not, have board representation. Certainly, if it's a 100% owned portfolio company, by definition, you'll have board representation. But do you think it is, in fact, a facts and circumstances driven test, or am I missing something?
No, you're absolutely right. And the facts and circumstances that really matter are the involvement of the private equity firm and the directors that it appoints to the company's board in the conduct that is alleged to violate the antitrust laws. So where this is most dangerous is price fixing. So if it's one thing if the board knows the prices that the company's charging. It's another thing if the board knows that the company has had discussions with its key competitor about the need for both of them to raise prices, and we're going to do this by bidding. I'm not going to bid on this contract, or I'm going to bid this on this contract, and you're going to bid that on that contract. I mean, if board members or the private equity folks know and approve of that conduct, they're at risk of being named in a private class action and challenging that conduct, and depending on the level of involvement, potentially criminally. So no different than really sort of any executive at the company, but just owning the share. I think courts are not prepared to just make ownership a crime, even for private equity firms. So that's the good news.
Ownership is not a crime. I love it. That'll be the tagline.
I think the courts are recognizing that folks can wear different hats. So if you're acting as, if you're at an appointed position as part of like a portfolio company, as long as you're acting in that position, you shouldn't also, because you hold a position in the private equity group, rope in the private equity, as long as you're acting with that hat on. The courts are still recognizing those distinctions.
Yeah, it's very analogous to the piercing the corporate veil phenomenon that corporate lawyers see all the time in the context of just straightforward corporate governance issues. Cool. Well, nice overlap.
The plaintiff's class action bar, I think, will be leading a lot of the charge here because they're looking for dollars, right? And they know where the deep pockets potentially are.
Yeah, no, absolutely. We're coming up on 10 minutes to the top of the hour, and I did want to make sure we take some time to answer any questions from the audience. So I'll ask those of you who are listening in, if you have a question, please submit it in the chat box, and we'll sort of see whether what we can do to help enlighten people.
While people are formulating their questions, I'll talk about one more case the FTC just lost because it's interesting in the hospital space. This was the FTC's case against Community Health Systems and Novant Health, involving a hospital consolidation in Charlotte, North Carolina. The FTC, when it challenges mergers, generally files two cases. They file an action in federal district court, which seeks an injunction to hold the merging parties separate until the FTC can adjudicate the merits of that case in its in-house administrative tribunal, where there's an administrative law judge who makes a final ruling. That ruling can then be appealed to the 5 commissioners and to a court of appeals. 15 years ago, the FTC had abandoned that, and then about 12 years ago, they reinvigorated that, and they try and convince the judge that you just have to figure out if there's like a serious issue here, and then let us figure it out. Most judges want a little bit more. They do want to see that there's some likelihood of success on the merits, which would typically be the test someone have to, the folks at justice have to meet when they're challenging a merger. Here, it was a concentrated hospital market. Atrium was seen as the largest. Novant was the number 2, and Novant was seeking to buy 2 facilities that were owned by Community Health Systems. Community Health Systems was losing money. The way the judge described it, it was going to drive these hospitals till the wheels fell off. Sort of was like somebody who's got an old car and is not putting any money into it, but is going to drive it and use it and make whatever money they can out of it until it collapses. But the parties convinced the judge that, look, absent this merger, these hospitals will disappear. They have huge capital needs. They are losing the technology arms race to get the equipment that's necessary to perform the most lucrative procedures. And although they weren't going to go out of business today, this was probably the best chance to preserve those hospitals as assets. And the parties were able to convince the FTC that there really wasn't anybody else around that was going to buy them. Or certainly not. Atrium buying them wouldn't be would be worse than Novant buying them. The court agreed with the hospitals and said, look, this isn't perfect, and my job's not to assess quality of care, but this deal will keep those hospitals in the market. And I think, based on the evidence before me, that absent this deal, these hospitals won't be in the market for much longer. And so, antitrust lawyers think of this sort of with the failing firm defense, which is really what this was, as kind of a Hail Mary. It seldom works, but here it did. At least, the denial of the injunction. I think the FTC is continuing to proceed in its Part 3 proceeding, and I also believe they're appealing the denial of the preliminary injunction. But you don't see the failing firm defense effective very often. But here, a lot of the issues we've been talking about today, the challenges in healthcare, came to bear in the judge's opinion. So it was noteworthy.
Well, and that goes back to the point that you were making earlier. We were talking about the need, humans need healthcare.
Yeah.
We don't all necessarily have to buy a BMW, right? And so there is this overriding policy, public policy concerns about you can't have a community without access to healthcare, right? Exactly. That's just the basic, the basic approach. Thankfully, it hasn't gone that far that we are treating hospitals like we are treating automobile manufacturers. Good stuff. Okay, it doesn't look like we have any questions from the audience, so I just wanted to take a moment to give a pitch to our upcoming seminars. We have 2 more seminars that we are going to be putting on. We'll take the summer off and let people enjoy their summers, and then we will reconvene starting in the fall in September. On September 18th, we will have a webinar, the 3rd in this series, entitled Major Fraud and Abuse Laws, Anti-Kickback and Self-Referral Prohibitions and False Claims, a big area in healthcare, how you navigate what the rules and regulations are with respect to fraud and abuse. So we'll have experts from the firm talking with everyone who's interested on the 18th of September. And then a month later, in mid-October, on the 16th to be precise, healthcare services licensure and change of ownership issues. Again, as you all know, this is a very heavily regulated industry, and licensing is key, and the ability to navigate when you need a license, when there's a change of a control, change of ownership, whether that triggers licenses, federal licensing, state licensing, other types of regulatory oversight. So that'll be on Wednesday, October 16th. Okay, so I think then that probably wraps it up, unless Len or Bill, do either of you have sort of parting words of advice?
Nothing else from me. Thank you all for joining.
Thank you very much.
Bill, thank you. Len, thank you. And to all in the audience, thank you so much for joining. Please feel free to reach out to any of us if we can help you with any of your needs. Have a great day, and we'll look forward to seeing you in September.
Thanks.
So long.
Thanks, guys.
Bye, everyone.